Thanks, Lindsay. Attorney General Nessel, obviously this ruling was no surprise, but how does it raise the stakes for the litigation now taking place in Michigan? And how confident are you that the 1931 law will be struck down by Michigan courts?
Well, I mean, obviously, we knew this was coming. It's not a surprise to anyone. It still feels very unnerving because now this is a final opinion. And before there was, still the opportunity that things could change. Well, they haven't. Both Roe and Casey have been summarily overturned. So that would normally ensure that the 1931 laws would immediately spring back into effect. As you know, they cannot because there is a preliminary injunction put in place by Judge Gleicher. And that remains the law in Michigan right now, is that the 1931 law is unenforceable as of this moment. Now that, of course, is subject to a higher court's review. And in the event that the Court of Appeals or later the Michigan Supreme Court were to overturn that, then the 1931 law would spring back into effect. But as of right now, it is unenforceable. So everything remains the same as it was yesterday at this time, but just for now. In terms of what the findings will be by the Michigan Supreme Court, say in the governor's case or in the Planned Parenthood case, should it rise to the level of the Michigan Supreme Court? I can't say. Do I think that there are some very meritorious arguments that are being made? Absolutely. Should the Michigan Supreme Court rule in favor of the governor? Absolutely. I believe the court should. And of course, I believe that the court should take the request by the governor for executive message and, move forward as expeditiously as possible. But, the important thing to note is, firstly, again, the preliminary injunction remains in place. That means in all 83 counties, abortion remains legal as of right now. Doctors, patients can go about their business exactly as they would have prior to this Dobbs ruling being formally issued. But what I would caution is this. Firstly, I think that it would be unfortunate, even if the court were to rule in favor of the governor, for the residents of the state of Michigan, for the voters of the state of Michigan to rely upon the Michigan Supreme Court to save reproductive rights for Michigan residents. What we've seen, if anything, as a result of the Dobbs decision, is that courts are subject to change their decisions, to change their rulings, predicated, of course, on who happens to be sitting on the bench at that particular moment. I mean, we can no longer confidently look at stare decisis as any sort of a measure of what the court will do moving forward. If we've learned anything, it's that all rulings by any court are temporary in nature. And so what I would urge the people of the state of Michigan to do is to ensure that if they're a registered voter, that they sign on to the Reproductive Freedom for All voter or ballot proposal. And if the requisite number of signature thresholds is met, then it will go on the November ballot. And at that point, the voters will have an opportunity to enshrine these freedoms, reproductive freedoms, to abortion and to birth control, as well as to artificial means of reproduction like IVF. They'll have the opportunity to codify that into our Constitution. And what that will mean is this. It means that no Michigan Supreme Court decision can later impact reproductive rights, no matter who sits on the court. And it will also mean that will supersede any statutory authority, so that the legislature then cannot make an effort to curtail reproductive freedoms via regular legislation, because these will be constitutional rights that will be held by each and every Michigander. So that is what I'm urging people to do. Would I like to see the Michigan Supreme Court rule in favor of the governor? Do I think she has excellent arguments? Yes. I do, and we've supported those arguments. In fact, on my behalf, I filed an amicus brief in support of the governor's arguments. But again, if we've learned anything, it's that the holdings of any court are tenuous in nature, and it's up to the voters to codify these rights into law themselves and not to count on a court to do it for you.
Thank you.
Grant?
Hi, Attorney General. A Right to Life spokesperson told us this morning that if you don't enforce the 1931 law or defend it in court, that you don't deserve to stay in office this November. What's your response?
I don't remember Right to Life being upset when Mike Cox and Bill Schuette didn't enforce the adultery laws. I don't remember them being upset when they didn't enforce the Ethnic Intimidation Act, hate crimes laws, or domestic terrorist laws, as I have done. I don't remember them being upset when Mike Cox and Bill Schuette didn't enforce the payroll fraud laws or environmental laws. So I don't understand how they can say that I don't deserve to be in office, because I have chosen not to enforce a law that I know will affect the health, welfare, and safety of the 2.2 million women of reproductive age that call Michigan home. I will not place their lives in jeopardy.
Dasha?
Hi, Attorney General. Thank you so much for taking the time. I am in downtown Grand Rapids right now talking to voters. I had a woman named Virginia come up to me in tears. She wanted to say something, to do something, and she is in her 60s. She was 18 years old when Roe took effect, and she's terrified about what's going to happen here in Michigan. As voters see this news, but also see news yesterday, some of the lawmakers here proposing a bill that would punish abortion providers by 10 years in prison. What can voters like Virginia, what can they look to you, to Governor Whitmer? What can they look to the state's leadership to be doing right now? As you know, this court case is not the end all be all. There are going to be more proposals like what we saw yesterday. What can they look to you to protect these rights, not just right now, but several election cycles from now when you all will no longer be in office?
Well, firstly, I think that the voters can be confident that Governor Whitmer and myself will do everything in our authority to protect the reproductive rights of the people of the state of Michigan. So that's clear that we're doing everything and anything within our executive authority. So let me give you a for instance when it comes to that. We represent Lara, and we also represent all of the medical licensing boards for nurses, for doctors, and so on. And what I have pledged is this: I am not going to seek to discipline, to suspend, to revoke the license of any medical professional who is properly trained in performing abortions or prescribing abortion medication, and then who proceeds to do that. I will not involve my office in that. And as I've indicated before, of course, neither will I enforce this draconian 1931 law that I think will hurt so many people in our state. I know that the governor has instructed all of her agencies to carefully review what measures they can take within their authority to protect the lives of women in our state in every way conceivable. But when you're talking about something long-term, when you're talking about after I'm termed out of office, after Governor Whitmer is termed out of office, I think really what people need to be doing is thinking long-term. And to do so, all you have to do is get this ballot proposal passed. And I think that is the best way, the easiest way to ensure that these fundamental rights are codified into Michigan's Constitution, not just for now, but for years or decades to come. Obviously, it's a difficult process to repeal a constitutional provision. I think it's important that we put one into place and we do it as quickly as possible. And what people need to do is mobilize. If this is an issue that you care deeply about, and most of us do, it's time to, get off our couches and to understand that this situation is dire, but it's not hopeless. And we are not helpless. And there is something that we can do, but it really requires everyone who is eligible to vote to make sure they register and to make sure that they actually go out and vote in our elections.
Thank you so much.
Stella?
Hi, AG. Thanks for taking the time. Two questions from us. One is today in the opinion, Justice Clarence Thomas said that the Supreme Court needs to take a look at not just Roe, but also precedents on, contraceptive access, on, same-sex marriage and same-sex sexual relationship. Do you foresee the possibility of the Supreme Court acting on that? And what would that mean for Michigan? Are you concerned about that at all?
Yeah, I don't just see the possibility of those kinds of cases being reevaluated. I believe it's a probability. And remember, it's not the Supreme Court that brings a case. They are outside parties that will now bring challenges. Now that you've eviscerated essentially the penumbra of rights for the right to privacy under the Due Process Clause of the 14th Amendment, these were the building blocks. Roe was the building block upon which many other important rulings stood and were held. So now that you have, eviscerated that as a area of jurisprudence, I think you do have to be very worried now what it means for those other rulings. Let's talk just for a second about what that would mean for Michigan. So right now, in terms of if you were to look at Griswold, if you were to look at Eisenstadt, we don't currently have laws on the books that I'm aware of that make birth control illegal, that those precedential cases overruled essentially or rendered unenforceable. But remember, if those cases are overruled by the United States Supreme Court, it means that our legislature would be free to enact laws to ban contraception in our states. And I will tell you, my opponent, Matthew DePerno, has said that he very much believes that Griswold was wrongly decided, and this should be a state's issue to make the decision as to whether or not people in our state can use contraception or birth control. When it comes to Lawrence v. Texas, very important to note that the sodomy laws are still on the books in Michigan. It is a 15-year felony to engage in intimate acts either with the same sex or an opposite sex partner if they are certain sexual acts. And so in essence, if Lawrence were to be overturned, immediately it would mean prosecutors all around the state could start prosecuting people if there was evidence that they engaged in those sexual acts, even though those are acts that could occur between two consenting adults, two married consenting adults. It would regulate the way people are allowed to have sex in the state of Michigan, and you will go to prison if you violate that, if a prosecutor chooses to prosecute you and you are found guilty. When you look at Obergefell, right? And of course, as everyone knows, Obergefell was actually part of DeBoer v. Snyder, was a case that was brought in Michigan, and that specifically challenged both the state statute and the constitutional amendment, the Michigan Marriage Amendment, which specifically outlaws same-sex marriage. So if Obergefell was to be overturned, then immediately same-sex marriage would be deemed illegal in the state of Michigan. So, these are really important holdings. They affect everyone in our state, virtually everyone in the state. And it is time to be concerned. And when we look at these kinds of laws, whether they ban birth control, whether they're the sodomy laws, whether it's same-sex marriage, these bans are highly unpopular amongst our state residents. But I think the thing to note is that the United States Supreme Court doesn't care about what Michigan residents want. And frankly, neither does this legislature, neither does the Republican Party. We have so many different examples of that. Same-sex marriage in Michigan, over 70% of Michigan residents believe that same-sex marriage should be legal, not the Republican Party. And you'll have to ask them what their feelings are about those other issues. But I am very afraid that if those precedent-setting seminal cases involving the right to privacy are overturned, then we could be in real trouble here in Michigan. And the thing to note about exactly what Justice Thomas said, that was a call to action for those who want to overturn those very important cases and eviscerate our right to privacy here in the state of Michigan for everyone.
Thank
Eli?
you. Oh, sorry, I had another question. Can I just ask
Go ahead.
that?
Yep, go ahead.
Okay, thanks. Yeah, so Attorney General, I was wondering what your take is on, how the 1931 abortion ban might affect abortion pills. In fact, just now, I think Axios reported that Attorney General Merrick Garland said that states cannot ban this FDA-approved abortion pill. So I was wondering what your read on that is. Thank you.
Well, I think that conflicts with the law in Michigan. We do have a law on the books that's specific to abortion medication, also passed in 1931. And, reading the text of the 1931 law, I believe that makes abortion medication illegal in Michigan. Not right now, again, because, of course, this preliminary injunction is in place. But in the event that it falls, and in the event that, the pending litigation is not successful, then I believe that abortion medication would be illegal in the state of Michigan.
All right, Eli.
Thank you for your time, Attorney General. Eli Newman, WDET, Detroit's NPR station. I had two questions, kind of different in scope. The first being, I know you spoke about the amicus brief that you filed on for the governor's litigation. I was wondering if there was any other litigation that you were considering also filing an amicus brief, or if there were other filings that you had already made.
No, not at this time.
Okay. And secondly, earlier this week, Congressman Tim Walberg had claimed that there was an act of domestic terrorism, pro-abortion domestic terrorism at the Right to Life office in Jackson, Michigan. I was wondering what your response to that, if there was any credibility to that kind of statement.
First of all, I'm not familiar with all the facts, and certainly I don't believe that was reported to my office. As Representative Walberg should know, I have a hate crimes and domestic terrorism unit in our office, and we're very aggressive about it. If he believes that to be the case, he absolutely should report it to our office. From what I have heard or what I saw involving the issue, was just a cursory glance on an article I read. It looks like vandalism. I don't know that it rises to the level of domestic terrorism. But that being said, obviously, I condemn any acts of violence and any acts of vandalism of any sort. We absolutely cannot be engaging in that kind of action. And if my office is involved, we will certainly enforce the law and ensure that if anyone is subject to acts of violence or vandalism, and those matters are referred to our office, that we will prosecute, people will be held accountable.
Jim?
Good afternoon, Attorney General. Two questions. Can you tell us all, as we're writing these stories, what kind of a time frame are we looking at, weeks, months, to get some definitive action from the state Supreme Court, so we know where this 1931 trigger law stands, a definitive ruling? Are we talking 6 months, a year out? How long theoretically could that take in your view? And the second one, while the issue of politics has come up, what's your comment regarding how much this issue can energize people? I know you were encouraging people to take part in the petition drive, but there could be people now energized to come out in support of your opponent, Matt DePerno, to make sure that this Supreme Court ruling stands in Michigan. So do you think this energizes voters on both sides of the issue is my second question. Thank you.
Well, as to your second question, I assume it does energize people. I assume that people who are avidly anti-choice, that it will energize them. And for people who want to see their rights protected, that they will also be energized. I assume it will remain true. I would caution folks who believe that this 1931 law is a good thing for Michigan residents. I want to make sure that it's clear to everyone. Again, no exception for rape, no exception for incest, no exception for medical emergencies, no exception in the event that there are gross abnormalities of the fetus such that you would have a child that dies immediately upon birth because they can survive in the womb, but they have such significant abnormalities that they would be unable to survive outside the womb. So for those types of situations, there's no exception of any kind. And I would further state this: yes, there is an exception to save the life of the woman, but we've never seen that defined anywhere. And so what does that mean exactly? So for instance, if you have a medical condition, high blood pressure or something else, where it's not a certainty that you're going to die during childbirth or during the course of your pregnancy, but maybe there's a 40% chance. Well, now, women just have to, I would say, live with the fact that there's a 40% chance they're going to die if they don't terminate the pregnancy, and it's going to be illegal to terminate the pregnancy. But I don't know that they can live with it because, again, there's a 40% chance that they'll die. I don't think that it's appropriate. I mean, I think even women who think of themselves as being very, anti-choice, very anti-abortion, perhaps don't want to risk their own lives, and hopefully neither do their family members. And so those are the kinds of things to think of. We heard that story, and we've heard it repeatedly, that Christine Morse was brave enough to tell a state representative from the west side of the state. And, she had a very aggressive form of breast cancer. And, what do you do when your oncologist refuses to treat you, refuses to provide chemotherapy or radiation or any of the other type of recommended treatment because you're pregnant? And unless or until you terminate that pregnancy, you won't get that treatment. Now, will you certainly die before you reach that 9 months and the child can be delivered? I don't think that a person could ever say that. So it's really a situation where that person just has to take a chance and hope that they won't die before they deliver, or that their cancer will not have progressed so much that it's fatal for that individual who is carrying the pregnancy. So these are the kinds of issues that, as anti-choice as a person might be, they probably haven't stopped to consider those matters. Let me add something else that I think is important people think about. Alternative forms of reproduction, such as IVF, in vitro fertilization. If you have somebody like, for instance, my opponent, Matt DePerno, who believes in the concept of personhood, which that means that life begins the moment of fertilization. Well, what is IVF? IVF is when you take sperm and you take an egg outside the womb and you create a zygote, and then you take the ones that you think are best suited for pregnancy and you implant them. Well, what happens to all those clinics now? I mean, if you are going to say, some of these are unsuitable to be implanted, we're going to dispose of them, are you now committing a felony offense by doing so? I think that somebody like Matt DePerno would argue, yes, you are, which would mean that all the infertility clinics in the state might have to shut their doors. Now, again, let's be clear, they don't have to do it today because this preliminary injunction is in place. But I don't know that that's something that a lot of people are thinking about. So when you talk about who's going to be mobilized, I think people should, ensure that they really take a close and careful look at this law. Let me say something else about the law. It's not clear to me whether or not a woman who seeks out her own abortion medication and takes that medication, self-administers that medication, whether she can also be prosecuted under this law. Now, there is case law from pre-Roe years that says that the woman is essentially considered to be the victim and not a defendant or a perpetrator or a suspect in these cases. But that was before we had this kind of medication where she could self-administer it to herself. If you look at the language I think one could read it to interpret it as though women could also be prosecuted under this law. And there are many other factors to look at. Back in the pre-Roe days, women were held in custody and could be held in contempt of court if they refuse to cooperate with a prosecution. And so what if you have a set of circumstances where there is information that a doctor is performing abortions and, someone like Matthew DePerno or another prosecutor who wishes to aggressively enforce these laws gets search warrants and subpoenas, goes into a doctor's office, can review all of the patient files, see what kind of procedures the doctor is performing, and see how they are coded in their medical billing, and then try to force these women to comply with subpoenas. And if they don't, what happens? Well, likely many of them will be held in custody and they'll go to jail until or unless they cooperate with the prosecution. So I bring all these things up because these are all the kinds of eventualities that we're likely to see in the event that these 1931 laws are held to be enforceable.
Can I have you go back to my first question, please? And that is, what's a likely time frame where we will have some definitive action, definitive decision from the state Supreme Court?
Well, that's a question for the state Supreme Court.
In your view, how much time do you think we're looking at?
Honestly, Jim, if I had a crystal ball, I could answer that question for you, but there's no way to know. We could get a ruling immediately in the next few minutes that they have decided to accept the governor's case, and they're going to hear the case for themselves. Or we could, there's no specific time frame that the court rules provide. And I do have some of my staff on here, so please let me know if I'm unaware of specific court rules that indicate a timeline by which the court must respond. But here.
No, you're correct. The AG is correct. There's no timeline for the Supreme Court. They can choose their own timeline. We can note, though, that the governor at 1:00 today filed a motion with the court requesting an expedited briefing schedule in her case, asking again that they certify the question. And under the governor's proposal, all briefing would be concluded in the month of July. Again, that doesn't mean the Supreme Court will abide by that briefing schedule, and it doesn't mean that the opinion would come out shortly thereafter. But the governor, like the AG, understands the urgency of the issue and is trying to use and do everything in their power to move the issue forward as quickly as possible.
Are you encouraged, AG, with the current makeup of the state Supreme Court and the people who are sitting on that bench? You made that reference earlier that decisions can change with different people sitting on the bench. The current bench, does that lean in your favor?
It's really hard for me to make a prediction on that. Obviously I am hopeful that they will be persuaded, that the Michigan Supreme Court will be persuaded by the governor's arguments. And again, as I indicated, I think they're very strong arguments, but I think you get into dangerous territory anytime you try to predict how a court will rule. And I've been practicing law too long to engage in that.
Thank you.
We'll go to Beth.
Hey, thanks for taking these questions, Attorney General. I had a quick question. So I know there's an appeal in the Planned Parenthood case by 2 county prosecutors who said, hey, that AG Nessel, you were the only defendant in the case and that they weren't named. And so this ruling shouldn't and doesn't apply to them. I spoke to their lawyer earlier today and he maintains that if they wanted to, even with this preliminary injunction in place, they could enforce the law, that if a case was brought to them, they could make decisions in that realm. I was wondering what your thoughts are on that, whether, because you have said before too, that you don't have authority over them to by extension and join them through this injunction. So I was just hoping to get your thoughts on that. Do you think this injunction applies to all county prosecutors throughout the U.S.? Throughout Michigan?
Sure. So what I had maintained before is that I didn't believe that I personally had authority to tell the county prosecutors what they could and could not charge. But who can? A court of law. So when I passed along that information, as I was ordered to do, I simply passed along how the court had ruled and what the court had ruled. And that was the issuance of this preliminary injunction. And, the theory, I believe, espoused by the court is that, even though I was the named defendant in that lawsuit, that it applied equally to all prosecutions in the state. But then again, that's something that I think would have to be expounded upon perhaps by the court. And I'm not going to take a position on that.
So would it surprise you if you saw pro-life prosecutors start enforcing this?
No, it wouldn't surprise me.
Alex?
Thanks for speaking with us, Attorney General. Do you think that your support of the proposed constitutional amendment to enshrine affirmative right to abortion care in Michigan undermines the argument that there already is affirmative right to abortion care in Michigan in the state constitution? To me, there seems to be a tension there, and I'd love to get your thoughts on whether or not you think the case is being undermined by the petition circulating right now. Thank you.
I don't think so at all. And let me give you sort of a parallel to that, right? In March, I argued a case called Roush World versus the Michigan Department of Civil Rights. And in that case, I argued that the word sex should properly be interpreted to include sexual orientation and gender identity. I'm waiting to hear how the court rules on that. But irrespective, I still support amending Elliott Larson to specifically include those classes. Why do I do that? Because again, courts can change. And maybe one court interprets sex to include those other classes, and then another court says something else. And that's why it's so important that it be in black and white and it be right there in the statute. Not because I think my argument was wrong. I think I was dead on, and I'm hopeful that I'll win that case. And I think I should win that case. But that being the case, I still support the amending of Elliott Larson. I think this is no different than that. Do I think that those 1931 laws, do I think that they are unconstitutional under our Michigan Constitution? I do, but that doesn't mean that we still shouldn't make sure that they are officially codified into the Constitution so that it doesn't lend itself to a wrongful interpretation by any future court.
Kashi?
Thank you, Attorney General, for taking my question. So this has been covered a little bit, but I would like to kind of just focus more on the issue. Outside of the group of reproductive women, there's still a lot of people, especially the LGBT community, who will be directly or indirectly affected by Roe overturning. There is threat to emergency contraception. There is also threat to IVF currently. And, the Michigan LGBT community really looks up to you as the first LGBT member openly elected in Michigan office. So what would you like to say to them? What would, be your statement right now as they're, in fear and in grief? What would be your response to them?
It's my same statement that I'm making to everybody today, my same appeal that I believe the voters of this state should rise up, get registered to vote, get activated, get motivated, and make sure that you are investigating each and every candidate for office, whether that be somebody who's running for, a local trustee position, or whether it's whoever's running for governor and everyone in between. And that includes, of course, our federal offices, and it also includes our Michigan Supreme Court candidates. See what their position is on these issues, and then vote in accordance with your values. I mean, we are not helpless. We still have the right to vote in this state and in this country. And it's what I suggest everyone who cares deeply about this issue does.
Eric will have our last question today.
Hello, Attorney General. I just wanted to kind of ask, since there is this temporary stay on the 1931 law, why is there such an urgency to have the Supreme Court decide if right now abortion is legal in Michigan still because of that decision? Why is there such a push to get a final answer if it's legal as we speak right now?
Well, there's a multitude of reasons, but let me give you some examples. If I'm a healthcare provider right now, I don't think I feel very comfortable with this preliminary injunction. And again, remember, the preliminary injunction right now, as it's written, there are specific plaintiffs that are involved. There might be questions as to how that applies to a third party. But in addition, again, this involves the enforcement of this 1931 felony statute. It doesn't say anything about whether an insurance carrier can drop you or not. It doesn't say anything about whether you can maintain your license to practice medicine. It's only about whether or not you can get charged with this 4-year felony offense. And so if I'm, a medical provider right now, I want certainty. I want a ruling from the court. I don't want this temporary stay. I want to know for sure if I engage in these medical practices that I have performed for decades, will I lose my license? Will I lose my insurance? Will I go bankrupt? These are the kinds of questions that need to be answered right away. And can a person be prosecuted for if they perform these procedures while this stay was in place? Very unlikely, but who wants to take that chance?
Okay, thank you all for making the time. AG, thank you for clearing your schedule for this. I did record this, so if you would like the recording, please send me an email to AG Press and I'll make sure you get the full recording.